We're on the record in two cases. First case is cause number 317394. And the second case is cause number 328368. Both cases are styled the state of Texas versus Reginald Cole. And is that your full name?
Yes, sir.
How are you doing, Mr. Cole?
I'm doing fine, man.
That's good. Mr. Cole, you're here. Two cases. First case is the motion to revoke your probation. And the second case is a DWI second, which is not a motion to revoke your probation. Now, you're represented here by Mr. James Padgett. Mr. Padgett, do you have an announcement on these cases?
Yes, Your Honor. Well, on the second case, Mr. Cole has hired me. I've requested all the discovery. I have not received the DVD video on the dash cam and the body cam on the DWI second. I would request that you allow me time to receive the videotape and review that with my client.
Okay, now what about, now the first case, he didn't hire you?
No, I'm hired on both cases, Your Honor.
Okay,
The motion to revoke probation is based on the new law violation, which is the DWI second.
okay.
So obviously,
So you need both of these
very important.
reset. Now, see here on this DWI second, did Mr. Cole get any bond conditions on this?
Your Honor, this is our first appearance, so I'm not certain if he has bond conditions or not.
Yes, sir, I do, Your Honor.
You do?
Yes, sir. I allowed bail bond.
No conditions on it.
Okay.
Oh, no.
Oh, okay, okay, you misunderstood. What we're going to do, you reach in that blue folder? Copy this here. Yeah, and I'm gonna go back on the record on this one. Let me get this here to you. She's gonna go make a copy. This is just a blank one right now, but she's gonna make a copy of the one with my
Yes,
signature
Your
on it.
Honor.
Just in interest of saving time, I'll just go over this with you.
Yes, Your Honor.
Now, you can get that to Mr. Cole. Mr. Cole, what you have before you is what is called standard bond conditions in County Court Law number 2. Do you see that?
Yes, sir.
Okay, I'll go over this with you. It says, following the arrest and or accusation in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or ordered subject to the following conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs or alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body, and that's pursuant to Texas Code of Criminal Procedure, Articles 17.1 44 subsection A2 and subsection C2. Do you understand that?
Yes, sir.
Let me give you that's the written one, you could get it now. That's the written one with my signature on it. Now, condition number 3 says the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. The defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that? And I
Yes, sir.
understand in this case there are, there's no individual victim. Now, the other condition is, and this applies to you because you have a subsequent DWI, which means this, you have a DWI second or more. A
Sir.
defendant who has been arrested or accused of any subsequent offense listed under section 49.04 and 4906, that's the DWI statute of the Texas Penal Code, shall not operate any motor vehicles unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day after arrest. And I would change that to, we'll give you 10 days from today to get the interlock installed and get your attorney could get verification, or you or your attorney could get verifications to the court of the installation. Do you
Yes, sir.
understand that?
Yes, sir.
All right. So, Mr. Cole, both your cases are going to be reset. He got 10 days to get us the verification of the,
You can get that to me and I'll present it to the court party.
yeah, you can make a note on that. Okay, so you can give him standard, you want to just give him a standard reset?
Fine with me, thank you. What's that?
March 26th. James Blackshear. We're on the record in cause number 324906, the state of Texas versus James Alfred Blackshear III. Is that your full name?
Yes, sir.
Okay, how are you doing, Mr. Blackshear? That's good. Mr. Blackshear, your case is on the court's announcement docket. You're here represented by your attorney, Mr. James Paget. Mr. Paget, do you have an announcement for the court?
Your Honor, I don't at this time. I've discussed the case with Ms. Ramos. I think I'll let her take over from here and then I'll respond to when needed.
Yes, Your Honor, we've discussed the case, and the biggest issue with this case is the amount of the restitution in it. And both Mr. Paget and I are in agreement that there is a discrepancy in the possible amount of the restitution, but we would like to set this for a restitution hearing to have the victim come in so that we can try and determine what the restitution value is.
Okay, how much time do you need?
I would request at least 30 days so that I can have a subpoena sent to this victim.
And the
Okay.
defense is not opposed to that.
Okay,
Your Honor.
give at least 45 days. We're going to give at least 45.
Whatever pleases the court, Your Honor.
Now, this is gonna be a restitution
Hearing, yeah, we can set it probably on a Friday.
Friday's fine. Your
Yeah,
Honor.
4/16.
or it's gonna be on 4/16,
Thank you.
April 16th. You can get reset. You and your client will be free to go.